In this video, I'm going to talk to you about the federal citizen. Okay, federal citizens, I believe, are to have a commission. Those are the officers, which are related to military, as opposed to employees, which are civil positions. Employees of the federal government are hired, whereas those in service to the country as officers are elected. And those elected, according to the Constitution, are in service to their country. So those elected are the congressional members and the president, whereas the justices are appointed. And in the Constitution, the members of Congress and the president are federal citizens, whereas the justice in Article 3 are not required to be citizens. They may be citizens, but they are not required to be citizens. And I believe that they are employees and they're appointed. And they are in a civil position, whereas the members of Congress and the president are in military positions in service as federal officers. I know this sounds a little strange, but I'm going to show you some things and you will come to understand my point. So we start with Washington becomes a private citizen. He resigns his commission. And this is from a book called Washington and the American, let's see, Washington. I got this somewhere. I got this book name somewhere. I'll find it in a minute. Washington and the American. So he says, "This is my last letter I shall write while I continue in the service of my country. The hour of my resignation is fixed at 12 today, after which I shall become a private citizen on the banks of the Potomac." So those in service to the country are federal citizens. He has a commission, so he's a military officer. And Article 2, Section 2 of the Constitution, which I will show you, shows that the president is the commander-in-chief, which is a military position requiring a commission. So when he retires, he becomes a private citizen. This is the preamble to the Constitution, where the delegates say, "We the people of the United States." And basically what this says is, we work for the United States of America. So in order for people to accept that these people are going to work for them, they have to do things such as have certain period of time as a federal citizen, and they have to have an oath. They have to be a certain age. Okay, so then they're hired and they're paid to serve their country and do things for their country. So the House of Representatives are required to be 7 years a citizen of the United States. To become a citizen, some of the earliest laws show that someone such as a clerk would go to the federal government and work as an employee, a clerk, for 2 years. And if they had good behavior, they could apply to the court of record to become a federal citizen. And after being a federal citizen for 7 years, they could then run for office and be sent as a member of the House of Representatives. And for a senator, because senator means senior, which means wise, they had to be 9 years a citizen of the United States. So that's a federal citizen. Because a federal citizen is someone who's on federal lands doing federal work and receive a federal salary. Now in Article 2, now remember I told you in the preamble, the United States works in service for the United States of America. In Article 2, Section 1, the executive power is vested in a president of the United States of America. Not the United States. So there's two places. There's the United States and there's the United States of America. So we go to Section 2. No person except a natural-born citizen or a citizen of the United States. So a natural-born citizen does not have to be born on federal lands, but a natural-born citizen is a citizen of America, the United States of America, or a citizen of the United States, and I believe it had to be 14 years, a citizen of the United States. So he had to have 14 years in service as a federal citizen. So you could be first you could be a member of the House of Representatives, then you could be a senator, and then if you wanted to, you could be the president. So it says 14 years, a resident within the United States. So a natural-born citizen is someone who's born in America, United States of America, right? Who they work for. Or 14 years a resident within the United States, the federal lands, a citizen of the federal lands for 14 years on the federal lands. Resident means you're living on the federal lands. Okay, now you go down to Article 3, the judicial. They are not required to be citizens. They're required to have good behavior. They were not required to be at the seat of government 100% of the time because it wasn't expected that they would be needed daily, that they would only be needed from time to time to hear cases that had to do with the interpretation of the Constitution. Of course, now we know this is a full-time job. But they weren't required to be citizens of the United States. They weren't required to be federal citizens. They weren't required to live on federal lands, to be a resident of the federal lands. Now we know, or most of us know, that someone in the military, an active duty officer, is required to live on the federal lands. Of course, nowadays they let them live off the federal lands because since the 14th Amendment, They're also citizens of the states, but they're still subject to the jurisdiction of the Constitution because they have an oath. Having an oath makes you subject to the jurisdiction, makes you under that power and authority, which means that you are under the judicial power. So if you violate your oath, you come under the judicial, the justice created by the Constitution, which are not citizens of the United States. So if a federal citizen, being someone in Congress or the president or any of the officers who have an oath, who are federal citizens, violate the oath, they're judged by those people they work for, those not on the federal lands, United States of America, because the justices are not citizens of the United States. They're not federal citizens. They're not private citizens. So, what do I mean when I say subject to the jurisdiction and being on the federal lands? During Eisenhower's administration, he put together a panel of people called a committee. And in this document, they talk about the Constitution and what it all means, and who are the people on the federal lands and who are off the federal lands. Okay, so this is part of the document I just showed you. Jurisdiction over federal areas within the state. It's a report. This is from part 1. So the Constitution says that the federal government was given some lands to do their federal work. And that's in Article 1, Section 8, Clause 17. And the work that they were to do is listed above that through Article 1, Section 8. And these are called the federal areas within the state. Let me help you understand this. This is from Article 1, Section 8, Clause 17. The federal lands are the district called the seat of government of the federal government, the seat of government of the federal government, the federal lands. And like authority, and this phrase like authority has been scrutinized by the government itself to find out its meaning, because it says exercise exclusive legislation in all cases over the district or Washington, D.C., which is the seat, and like authority over the places purchased by consent of the legislator of the state. So these are called the federal areas within the states. Okay, that's the places purchased. Places purchased are called the federal areas within the state. Okay? Now, this whole report is the study of the power and authority over the federal areas within the states. And this is where the federal citizens reside. This is where they live. The members of Congress are supposed to live in the federal areas within the states. It says that right there in the Constitution. Now they call these areas a lot of different things: islands, enclaves, outlets, areas, lands, federal areas, federal property, real property, posts, they call them military reservations, military lands, bases, stations. They call them all sorts of things. But what they call them doesn't matter as much as who's speaking of them and what they can do on them. I've got something here on jurisdiction. It's an old definition. It's been around for a long time. I believe this is in either a 16 or 1700 dictionary. You see that a lot of dictionaries will use lowercase, all lowercase words, or they use all uppercase for the word and then lowercase for the definition. But the old definitions and encyclopedias didn't do it that way. They were very proper in the way that they wrote things. And if you look at this definition, you'll see you have a capital J. First letter, of course, is capitalized. Capital A for authority. Capital P for power. Capital M for man. Capital J for justice. C for causes. C for complaint. And then looks like a colon of K, P, R, F, V, R, P, lands. Okay, a fee. The other is a jurisdiction given by the prince. That doesn't apply here. So jurisdiction, it's proper. It's a proper noun, meaning it's a specific type of jurisdiction given specific authority and specific power for specific men to do specific justice, specific causes of specific complaints, all very specific. It's not arbitrary the way the prince has jurisdiction where he can basically do whatever he wants. Jurisdiction, according to our Constitution, is limited and defined. Okay, limited and defined. The Constitution is written in much the same way this definition is written. So jurisdiction, when we're talking about jurisdiction, we're talking about the things that Congress is allowed to do, which are specifically written. Okay. They get paid. Reason of his fee, they get paid. They have to do the right thing on the lands within his fee, the lands that they're given. So in the Constitution, where it says these are the laws of the lands, it's not the entire country. It's not America. It's what they do on their lands that they bought, and they get paid to run the way the Constitution says, exactly the way the Constitution says, not the way that they decide the Constitution says. And besides, they can decide the Constitution says whatever they want, but what do you believe? Do you believe it applies to you, or do you believe it applies to them? I'm telling you it applies to them, and it does not give them the power to apply anything against people not on federal lands. And I'm not just telling you, I'm showing you. And this is chapter 1 of the same report. Okay. I'll bring up the report again. You can find this book online. Jurisdiction. Remember, that's power and authority, or power or authority, whichever you want to see, over federal areas inside the states. So let's word this differently according to the simple words that are in the dictionaries as definitions. Power or authority over lands purchased by the federal government with the consent and inside the states and their legislators. This is a report explaining what this means. Okay, now this is the first chapter telling you why they did this. And I'll summarize this. So there were officers and employees, and if you want to look more into officers and employees of the federal government, look to the website. You can Google it, OLRC. You'll come to a federal government website called the Office of the Law Revision Council, and you'll come to a list of titles, and you go to Title 5, and you can read all about who the laws apply to, officers and employees of the federal government. Well, these employees, some of them were living and working at a VA department back a long time ago. And they were not allowed to go off the state because at the time this was happening, there was no 14th Amendment allowing them to also be citizens of the state. So what they did was they sued in a local court. So the people on the federal lands sued in a local court because they wanted to come off the federal lands and use state resources. But the state said no in the local court, and then they said no in their Supreme Court, state Supreme Court. So then they sued at the federal level, and then they still lost. But what happened was then the government, the federal government, decided to pay the states to allow the federal citizens to use state services, and they charged those costs back to the officers and employees on the federal lands, the federal citizens, because they were the federal taxpayers. And that's in the 1939 tax code, stating that taxpayers were, in fact, the federal employees working for the federal government, receiving federal money as their fee for doing federal work. Not private citizens. Private citizens or American citizens who are private citizens are not taxpayers, not federal taxpayers. So after these contracts were made between the federal government and the states individually, the federal employees became state and federal employees, or state and federal citizens, but they were still subject to the jurisdiction of the federal government. And that was passed, I think, in 1864 or 1868. The entire Constitution is talking about what the government is going to do for, in service to, the country. not what the federal government is going to do to the people of the country or the states, but what they were going to do for them. They were going to stay in their respective responsibilities in order to be of service to the country so that a goal could be achieved. And that goal was defense, building up the defenses. I don't want to get too much off topic because I want to make sure that I'm explaining this in a way that people can understand that they are not a federal citizen. They are only citizens of the state. So I want to go back to the Constitution. There's a distinguishment made in here, which many people just don't catch on to because they don't really read the Constitution enough. But these people are the federal citizens, and they work for American citizens or people of the state. So you see, when it talks about what these people do and what they have to be federal citizens or citizens of the United States. These people are called people of the states. So these people are clearly not these people. And these people originally were clearly not these people. But these people were allowed to be these people and these people so that they could use the services inside this area or off federal lands. In this case, this is United States versus Woodbury and Minot, page 76. I've only been able to find this in reference books. I have not been able to actually find the case law on this. But it's in a variety of reference books written by the federal government. Where the United States own land situated within the particular limits of the states, okay, it says within the limits of particular states, or over which they have no cession of jurisdiction, for objects either special or general, little doubt exists that the rights and remedies in relation to it are usually the same as applied to other landholders within the states. So there are different types of jurisdiction that the federal government has, depending on who they have on those lands and what they're allowed to do on those lands. So to find more about jurisdiction, I go to a particular book. And I'm going to bring it up here in just a second. I'm going to show you the cover of this, which you can find at hathietrust.org. You can just search this book. Now, I found that on many of these websites, you have to search it exactly the way it's written or it won't come up. So, inventory report on jurisdictional status of federal areas within the states. This is a very interesting book. And it talks about, and notice this also in the pyramid, just pointing it out, that it points out the jurisdictions and it explains what those jurisdictions mean. And it references the report by Eisenhower. It references this report. So they kind of go hand in hand in understanding the entire system. So what I'm telling you is not just me trying to link things that don't belong linked together, trying to make a case. This is what they are telling you is what the Constitution is telling you, because not even they knew for the first 150 years or more. And they had to figure it out. And so once they figured it out, they wrote this, and this was in the 60s, 62. Okay, of course it's been declassified. It's this is the book that people who work in GSA, the GSA makes contracts for the Department of Defense. They write the contracts to hire contractors to work for the Department of Defense. So because they have people, just average people like me and you, writing contracts, they have to tell them how to do it, what it all means. They do studies and they explain, okay, to their employees what it all means. So adjusting the legislative status of their properties, okay, because they were legislating improperly, whether real property owned by the United States throughout the world, of the jurisdiction over the areas inside the states. Okay, so they've taken a long time trying to figure this out. And then they explain it. The codes they use for the states. And then the jurisdictions. These are the jurisdictions. You probably can't see it because it's small and you're probably watching this on your phone, maybe on your computer, but if you go back and pull up this book, you can read what power and authority they have on what lands, because they have some lands that they purchased and they have all rights to the land, just as the state would. They have some rights to property where they make laws for it, as well as the states. They have some partial right to property, partial right to make laws, and then they have only ownership rights. So this is proprietorial interest, meaning that they have the same rights as any landowner. So in the Constitution, they were to purchase these lands inside the states. And this is a question of, where the jurisdiction is. Is it proprietorial or is it exclusive? Because it says like authority in Article 1, Section 8, Clause 17. It doesn't say exclusive, it just says like. So does that mean that it is also exclusive, or is it something like exclusive? Is it concurrent? Because the states originally were supposed to appoint their own officers of the military and put them on their own lands that the federal government purchased, so that the states had control over who was on those properties. So the federal government would tax them and they would become federal citizens, is our current understanding. But if they only had like authority, are they really required to be federal citizens when they're on federal lands in the states, or what's designated as, so far as we know, as federal lands in the states? Okay, so these numbers, 1 through 5, are the jurisdictional codes that they use. Number 1 through 5 appearing in the jurisdictional code column indicates the legislative jurisdiction. So when they're writing these contracts, they would say the jurisdictional code is 2 or the jurisdictional code is 4. That's what they mean. So if you can get a hold of a government contract, you can see what the jurisdictional code is. I'd like to see what the Department of Justice's jurisdictional code is. I would like to see what the Centers for Disease Control jurisdictional code is. I would like to see the Texas Attorney General's jurisdictional code is. I would like to see what the state of Texas jurisdictional code is, because the state of Texas is a contract on paper, exists on paper. I would like to see what the federal IRS offices inside the state's jurisdictional code is. I would like to see what the all the other departments inside of the state, what their jurisdictional codes are. The problem is I can't seem to get a hold of any of the contracts or any of the charters. And that's probably why, because it will have a jurisdictional code in there that will tell you that they have no power or authority, because they're people just like us. They're private citizens just like us. Unless they're elected. And if they're elected, they have to be a federal citizen under oath. Background to the Attorney General. The General Services Administration established a central source of information concerning the legislative jurisdictional status of federal properties. So the Attorney Generals know. And I've asked them for information on the IRS inside of Texas, and they refuse to give me anything. They refuse to answer me, and they refuse to give me any papers or do an investigation. They refuse. I've asked other states, and they refuse also. I've complained that the IRS is doing a bait and switch. They don't care. They refuse to investigate. I've asked the IRS for a copy of its charter. It still hasn't answered me. They send me letters every once in a while saying that they're still investigating, and they'll get me an answer as soon as they have one. But for 2 years now, they don't have one because they won't send it to me. They won't send it to me because it has their jurisdictional code on it. And their jurisdictional code is probably proprietorial interest only, meaning they have no authority. Or maybe there isn't a code because they have zero authority, absolutely zero authority. Because they're not federal citizens, and even if they were, all their stuff only applies on federal lands. The federal government exercises, with respect to the District of Columbia, all those powers, judicial, executive, and legislative, which under our federal, they call it a federal-state system of government, are ordinarily reserved to the states. It is not so well known that under the second portion of this constitutional provision, the portion that has been emphasized above the federal government has acquired like authority with respect to numerous other areas within the geographical confines of the states and with respect to the residents of such areas. These other areas, sometimes called enclaves, are in effect federal islands surrounded by state territory. So they're just federal lands inside the state. To the extent that jurisdiction thereover has been surrendered to and accepted by the federal government, only the areas, only those islands inside the state territory, those are called federal territories, not state territories. The state territories are state territories, and the federal islands are federal territories. So when they say the territories, they're talking about all the federal areas inside the state, which in Texas are tiny. And there is a website that you can go to, a government website that shows you what all those areas inside your state are, so that you can know where the federal lands are. The states are deprived of the ordinary authority of the state and cannot, with respect to such federal enclaves or to their inhabitants, exercise usual state functions. But while the Congress has legislated complete civil and criminal codes for the District of Columbia and provided the local machinery necessary for the administration and enforcement of those codes, it has legislated little and provided little by way of local government machinery for such federal enclaves or for their inhabitants. So the federal areas in the state, they're saying at this time in 1960, whatever this was, that the federal government had done very little to legislate for the lands in the states. Which means all this stuff that they're doing, all these laws they're passing, apply mostly to the District of Columbia. It says it right here. That's what this says. That's exactly what this says. That the government is mainly passing laws for the District of Columbia. For the most part, it's because you're not a federal citizen and you're not on federal lands. Over the years, the peculiar legal status of federal enclaves has given rise to many serious problems. Okay, that's the legal status. That's the written law. Written laws are fictions because they're written by man. They can be changed and altered at will of the man. Whereas lawful things are true no matter what, whether they're written or not. That's what I call God's laws, because you can't really do anything about them. Men just find them out. They figure them out. The speed of light, gravity, that you get more by being good to people than you do being bad to them. The significance of those problems is being magnified as the impact of governmental action on the individual citizen continues to mount. So it's recognizing that because they don't understand the problem, or because people misunderstand the problem, that people misunderstand who they are, the problems with the individual citizens are just getting more, the impact's getting worse and worse. But I've made several videos on this, and people they keep calling themselves federal citizens, which is a citizen of the United States. They keep on calling themselves that. They can't get it through their minds. They can, but they choose not to accept that they're not a federal citizen. Not being a federal citizen doesn't mean that you don't support the federal government in its limited capacity. It just means that you're not going to be governed by it individually. You're not going to pay federal taxes. You don't have to comply with the CDC regulations. You're not going to wear a mask. You're not going to get their licenses. The only way that they can put you in prison for a federal crime is if you claim to be a citizen of the United States and you're subject to the jurisdiction, which so far appears to be only in the District of Columbia. In the past, such problems were handled on a case-by-case basis. In December of 1954, upon the recommendation of the Attorney General and with the sponsorship of the President and the Cabinet of Interdepartmental Committee, which is the blue book I showed you. That's the Interdepartmental Committee that was formed to study this subject. So all the answers are in there. It's telling you here, the answers are over there. Go get that book. And that's what I did. Was formed to study the entire subject of legislative jurisdiction of the federal government over areas within the states and to make recommendations thereon. So really all we need to do is understand these. You don't even have to read them. I'm reading them for you. All you have to do is accept that they're telling you you're not a federal citizen and you're not on federal lands. Why do you pay taxes? The extension of the federal government's jurisdiction over lands within the states and over the residents of such lands was slowed down with the removal on February 1, 1940 of the federal statutory requirement originally acted in 1841 that in the case of purchased lands, the consent of the state to such purchase be secured prior to construction of any federal building thereon. The acquisition of the jurisdiction of the federal government was further slowed down with respect to newly acquired lands by the findings of the above-mentioned committee. However, there does not exist any administrative machinery for canceling the legislative jurisdiction previously acquired by the federal government from the several states. So there does not now exist any administrative machinery for canceling the legislative jurisdiction previously acquired. So it's saying they can't correct their mistakes because there's nothing in the Constitution that allows it. But boy, they can do a lot of other stuff, can't they? It's called a repeal. It's called a repeal. You repeal it. States gave lands to the federal government. This is my note. States gave lands to the federal government that were already either owned by private people or private people were living there. Remember, Washington was a private citizen when he left the government. So anyone not in government is a private citizen. They were not federal citizens, but were state citizens, and the federal government did not know exactly how to legislate over them. They were not federal citizens, but were on federal lands. Some of those residents had children on those federal lands, which made them born in the United States. The objectives. The Interdepartmental Committee for the Study of Jurisdiction over Federal Areas within the state made the following conclusions and recommendations. With respect to a large bulk of federally owned or operated real property in the several states and outside the District of Columbia, it is desirable that the federal government not receive or retain any measure whatever of legislative jurisdiction, but that it hold the installations and areas, so the posts, military reservations, and a proprietorial interest status only, with legislative jurisdiction remaining in the several states. So it already gave legislative jurisdiction over those federal areas back to the states. That was its recommendation. That the federal government stop legislating for those areas. That those states legislate those areas. So this whole idea of becoming part of the federal government and being subservient and under it really doesn't apply because they only have proprietorial interest of those areas, meaning that they have the same rights as any other private citizen landowner. They have no more than that. And I believe that's why they had to create all of these offices and push to say that you have to obey them because they're the laws, when they're in fact not laws and owned by private corporations, because without doing that, they would have no power over all the people because they don't even have it according to the Constitution. Those areas are still legislative jurisdictions of the state. So lawmaking authority and power belongs to the state. Secession is when the states kick out all the federal employees, or they take back those areas from the federal government and don't let the federal government legislate for them at all. Okay, so it is desirable that in the usual case, the federal government receive or retain concurrent legislative jurisdiction, which means the states can legislate as well as the federal government. The federal government can only make the laws for its federal citizens who are on those areas. And you can come through and read some of this stuff. Source of data, the status of the various federal agencies with respect to the areas under their respective control. Scope, wholly owned government operations. Areas not covered. The whole of the area now consisting of the District of Columbia is under exclusive jurisdiction of the United States. It embraces, except for certain adjustments, the area that was ceded by the state of Maryland to the federal government for the purpose of establishing the seat of government and accepted by the federal government in 1790. The area that was ceded by the state of Virginia for that purpose and likewise accepted was retroceded to that state in 1846. So they ceded lands, they gave them to the federal government, but then they retroceded them, they took them back. These two areas together approximated the 10 miles square that is referred to in the first portion of Article 1, Section 8, Clause 17 of the Constitution. However, the District of Columbia, as a seat of government, involves special considerations not generally applicable to other federal areas. Accordingly, the above-mentioned Interdepartmental Committee, which is the Blue Book, restricted its report to those areas that are covered by the like authority and did not deal with the District of Columbia. The same considerations have led to the exclusion of the District of Columbia from this report because they already know they have exclusive legislative jurisdiction over the District of Columbia, so they didn't really need to investigate that. Inasmuch as the legislative jurisdiction involved in this report concerns the authority of the federal government in relation to that of the state, this report does not deal with property in the territories or possessions or in the Commonwealth of Puerto Rico. So here under definitions, it says federal government with respect to federal enclaves and their inhabitants varies as between states and even as between areas acquired at different times within a single state. Moreover, the Constitution has been interpreted as permitting the transfer of jurisdiction to the United States to be subject to and continuing jurisdiction of the states either in all or in certain limited aspects. In addition, the federal government has enacted various statutes to permit the states in certain cases to exercise limited jurisdiction over federal enclaves and their residents. These factors have led to an almost infinite variety of jurisdictional situations. That's where the unknown comes in because each state retained some things, some powers and authorities to themselves. The term public domain, as it applies to land within a state, refers to those lands which were acquired by the United States prior to the creation of the state and which are still retained by the United States, such as lands acquired by the federal government by virtue of the Louisiana Purchase. The term has no application to any land in the original 13 states or in Texas, which was an independent state prior to its admission to the Union, and at present has only limited application to the land in the states created out of the territory that belonged to the original 13 states. Public domain lands are to be differentiated from so-called after-acquired lands, which exist in every state. Much of what was originally public domain is now in private ownership through operation of the homestead laws and other similar laws. Other portions of the public domain have been withdrawn or reserved for military or other public uses. A state statute providing the constitutional consent to the purchase of lands by the United States, as opposed to the status directly ceding jurisdiction to the United States, would not operate to vest exclusive jurisdiction in the United States over public domain lands, inasmuch as the public domain, by definition, does not embrace land that has been purchased by the consent of the legislator of the state in which the same shall be. Moreover, in only a few states, such as Arizona, Nevada, and Utah, do the direct cession statutes of general application provide for exclusive jurisdiction in the United States over public domain land that is reserved for public uses. Also, in only a few cases, such as that of Yellowstone National Park, has exclusive jurisdiction for the United States been reserved in the Enabling Act by which the state was created. As indicated above, the statistical aspects of this report do not distinguish between public domain lands and after acquired lands. Okay, and here's a memo to the heads of the federal agencies, July 18th, 1962. This would be something good to copy and send to them. Just as a reminder that you do understand what their jurisdictions are and their limitations are, and that some places have no power. It's a circular attachment, GSA Circular number 275, report of legislative jurisdiction over federal areas within the states. For instructions, see GSA Circular number 275. Instructions for the report. This is Circular 275 on how to fill out this form. Proprietorial interest only. This term is applied to those instances wherein the federal government has acquired some right of title to an area in a state but has not obtained any measure of the state's authority over the area. In applying this definition, recognition should be given to the fact that the United States, by virtue of its functions and authority under various provisions of the Constitution, has many powers and immunities not possessed by ordinary landholders with respect to areas in which it acquires an interest, and of the further fact that all of its properties and functions are held or performed in a governmental rather than a proprietorial capacity. So on the one hand, it's telling you that they have the same title that most other people have when they own land, but because they're governmental, they're given some immunities not possessed by ordinary landholders, such as they might not have to pay taxes, or they might have a reduced tax burden. They may not have to comply with certain state laws because they have a federal function that if they complied with the state laws that they wouldn't be able to complete their functions or their missions or their whatever it is that they need to do. So the federal government can institute different gun laws, like the states. If the state instituted a gun law, the federal government wouldn't have to follow that gun law because its laws would be contrary to the state laws. Stuff like that. So the Constitution says these are the laws of the land, but the lands are only the federal lands. And even then, they don't have right to make any law that they want on those lands. It depends on in what way they own the lands. Whether it's, by one jurisdiction or another. So now let's go back to talk about some citizenship. So we're talking about people only on the federal lands. And so the federal government has a right to have some sort of control over not necessarily individuals, but over the classes of people. Now, of course, some of these books that I have are very old and they apply to the English laws, but many of the English laws are used all over the world because it's the basis of the law. It's a rule of action, and the rules of action are good in any place, but how they're applied differ according to what type of government you're under. So the people on the federal lands that are federal citizens are under the control of the federal government. But even then, they're only under a limited control. Unless it be assumed that the office is to begin and end with one person, the statute is addressed to a class consisting of all those persons who shall occupy the office created. So all of the senators, all of the House of Representatives, all of the justices, those are classes. They're each a class. And the law has to apply to them each individually, but as a class. It applies to all of them equally. Now, the president, he is an individual, and so those laws apply to him individually. So let's say all military officers have certain statutes that they all have to comply with, but an individual officer doing an individual type of work separate from others would have statutes that apply to him individually or her. So citizens is defined by, I believe this was written by Roscoe Pound. No, yeah, I'm sorry, Roscoe Lewis Ashley. The definition of citizen is a member. Members of Congress, members of the judiciary, members of the military. But instead of the word member, they use citizen. A man of the city. DC is a city. Okay, they're members of that city. The federal government, in this case, under our form of government. Okay, so the members. The members are called citizens of the United States. This was just recently found. I've done a video on it, but I went back and watched the video and you couldn't really see what I was reading, and I'd like for you to be able to see it. So this is the Congressional Globe, the official proceedings of Congress, published by John C. Rivers, Washington, D.C., 33rd Congress, first session, Wednesday, May 3rd, 1854, new series, number 67, and that means it's page 67. Now I can increase this in size. Unfortunately, it gets blurry. And so you'll have to go, if you really want to see this on your own, you're going to have to go look it up if you can't see it. So Mr. Howe, H-O-W-E, is talking about this phrase in a bill. And the phrase is white, male, American citizens of the United States. And then everyone laughs, or he laughs, it just says laughter. And Mr. Disney, D-I-S-N-E-Y, says, you know, what's the deal? What are you bringing this up for? I would personally like to point out that white is part of the issue in this congressional record, the word white. because Mr. Howell wanted that stricken out. But that's not what I'm talking about here. I'm talking about the phrase American citizen of the United States, because it wasn't just that they wanted white taken out, he wanted American taken out. And the reason why is because there's no such thing as an American citizen of the United States. And the people in Congress didn't seem to understand what he was talking about. And they're like, well, what's your problem? And he's like, well, that doesn't exist. You have American citizens and you have citizens of the United States. So you can't have American citizens who may not have an allegiance to the federal government be also a citizen of the United States. Because remember, here in the Constitution, it says citizen of the United States. It doesn't say American citizen, because you have state territory. In the other paper I read to you, it says territory of the state. And then the territories of the federal government, meaning the federal lands inside the states. Territory is just another word for land. The land of the federal government or the land of the state. Which one are you on? If you're on the federal territory, you're a citizen of the United States. If you're off the federal territory, you're a American. You're a state citizen. You're a private citizen. You're not a citizen of the United States. You're not a citizen of the United States until you take an oath and go to work for the federal government and receive compensation for services and take an oath and become a member. A member of Congress, a member of the judiciary. And actually, the judiciary is not required to be citizens of the United States. They're not required to be on the federal lands. Even though when they go to their office is on the federal lands. So that's what this entire section is about. And they did. They agreed and they struck it out. They struck out white American. They struck out white and American because it didn't make any sense. Because you have people on the territories of America and you have people on the territories of the federal government. People of the American territory are American citizens. People of the federal territory are federal citizens, and those federal citizens are called citizens of the United States. And they are members of the federal government, receiving compensation for services. They're federal taxpayers. Later in the 14th Amendment, allowed to also be state citizens and become state taxpayers and receive state services. And that's mentioned in the other paper that I read to you, well, that I went over from the Blue Book. And let's see what else I got here. Okay, I think I read this, the scope. Wholly owned government corporations. So these are corporations owned by the federal government or private corporations doing business on some of the federal lands, the lands purchased inside the state. So I want to show you something else. A brief inquiry into the true nature and character of our federal government, being a review of Judge Story's commentaries. This was published in 1863. And he says, Congress had no power to coerce those governments, nor could it exercise any direct authority over their individual citizens. Whether on or off federal lands, The federal government never had authority to do anything to people who were not citizens of the federal government. In 1848, Wharton, the Law Lexicon, Citizen, Aristotle, in the beginning of the third book of the Politics, defined a citizen to be one who is a partner in the legislative and judicial power. But the justices are not required to be citizens of the United States. Maybe that was just an oversight when they wrote the Constitution. I don't think so. I think it was intended to be intentional. I think it was intentional. City, a town corporate, which has usually a bishop and a cathedral church, is called civitas because it is governed by justice and order of magistracy. For that, it contains a great number of inhabitants and urbs, because urbs is suburbs, because it is due from, in its due form, begin about with walls. A city with walls. In Black's Law, sixth citizen, one who, under the Constitution and laws of the United States or of a particular state, is a member of the political community, owing allegiance, that's an oath, and being entitled to the enjoyment of full civil rights. Okay, that's the civil rights of the people of those lands. Civil. All persons born or naturalized in the United States, okay, in the United States, in the federal lands. And Black's Fourth, this was, I don't know when Black's Fourth was written, but was probably written before, I'm going to guess 1950. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. That's true, sort of. You just have to understand that all persons born or naturalized in the United States are federal citizens and on federal lands, meaning they're subject to the jurisdiction, and they are citizens of the United States, which according to this are legislators, judicial, and living on the lands of the federal city, and a member of the community, the political community. Citizens are members, so legislators, let's just use legislators. Citizens are legislators who in their capacity have established or submitted themselves to the dominion of a government. So they took an oath and they received compensation for their services. In service to America and American citizens or private citizens, and protection of their individual, not constitutional, but individual rights, individual and collective rights. Because if you're not a federal citizen, you don't have federal constitutional rights. You have all your rights, and they have some constitutional rights. They have their constitutional rights because they're supposed to protect you. So they gave up some of their rights, their natural rights, because they're legal entities now, which are fictions, which are like corporations and people not in their natural capacity, in a legal capacity, who have legal rights. Everyone else, not part of federal government or not part of state government, have all their rights. But federal citizens are inside states. And so they can be state citizens, but still subject to the constitutional jurisdiction. The United States is not the entire country. It's only the federal lands and the seat of government. And it tells you that in the Constitution. And since Aristotle, which the founders who wrote the Constitution, they were aware of Aristotle. They knew who he was. They knew what he said and that citizens were members. And so I'll end the way I started. Washington is writing to his friend, and he says, "This is the last letter I shall write while I continue in the service of my country as a citizen of the United States." Okay, I add that in. "The hour of my resignation is fixed at 12 today, after which I shall become a private citizen on the banks of the Potomac." You are a private citizen unless you work for the government and receive compensation for services from the federal government. And those people who are citizens of the United States, according to the Constitution, are the members of Congress and the president. They've expanded that to include all the members of the military, as well as their civil service employees, so that they can draft their civil service employees into the military if they need to. And they've made us all citizens of the United States by telling us that we are, making us believe that we are, taking over the education and telling us that we are since we're kids, having us sign all their papers, which their papers are forms, which forms are bills. Their bill is a poster. A poster is a notice. A notice is an advertisement. So their forms are advertisements. Their notices are advertisements. Not a true bill. It's just a bill. Things hung up on a wall for people to see are called bills. A list of people is called a bill. The actors in a play are called a bill. Whenever I was in the military and I had to stand watch, I would have to go check the watch bill to see what time I was supposed to be there and what day I was supposed to be there and what I was supposed to do. And then I would have to stand post. I would have to post in that place at that time and stand watch. Because that's what the poster said. That's what the bill said. That's what the advertisement said. And if I came back and said, well, I didn't know and I missed my watch, they would say, well, you were noticed. How was I noticed? It was posted. You know where we post the watch bill. Yes, I do. None of what the federal government does applies to you if you're a private citizen. What it does is they apply it to themselves for you. And that is all. You don't have to file their papers. You don't have to pay their federal taxes. You don't have to be regulated by the CDC. The Attorney General is not supposed to be putting you in jail. You can't commit a federal crime unless you're on federal lands. And even then, it's still questionable. You can't be picked up by federal officers. Most of what they do is not only unlawful, it's illegal by their own laws. But we all claim to be citizens of the United States, and they feel that that gives them jurisdiction. So you're saying you're out of the District of Columbia, meaning that you're part of the District of Columbia. That you're of the District of Columbia. You're just not in it right now, meaning that you're under the jurisdiction of it. So you don't have to write a letter to change your status. You just have to stop selecting on their forms that you're a citizen of the United States. When I went to get my state of Texas driver's license, it asked me, are you a citizen of the United States? Yes or no. I should have chosen no. Then they would have denied me a driver's license. That's not my fault. And if they put me in jail, I say, well, I'm not a citizen of the United States. It asked me and I said no. The judges don't care. They would probably still would have put me in jail and I would have had to stay there until they let me out. Because it's a standoff at that point. It's an act of war. Because without us, they're nothing. Without us using the Federal Reserve notes, the empire falls. and the Fed and the empire falls. How do you do that? Buy gold and silver. There's a lot of people in my area who sell fish off the back of a boat, sell shrimp fresh, eggs. There's a pig farmer not far from here. I can get meat from her. I can buy a whole pig from her. She'll take silver. The fishermen will take silver. I've got about 3 or 4 egg ladies here. They'll take silver. There's 2 farmers here that sell raw milk. They'll take silver. And I know it seems small, but it's a start. But you have to go get your gold and silver and start stacking. Because if they have no one who will take their money is useless. So pass this along, like, share, subscribe, and if you don't want to do 2 of those things, just share. I ask you to please share, because there's no way my information can get out without people sharing it. I do the best that I can, but it's not enough for me to do it alone. I post my links on YouTube, and YouTube deletes them, and I have a video on YouTube of them actively deleting my links and my comments, even comments without links. They'll just delete them. You can go through my video list and find that video where I refresh the page and I go back to the exact places, and all my posts are gone. Since then, they've stopped doing that, but that doesn't mean they won't start again. I've been kicked off Facebook and Twitter and Instagram, and I never even really used Instagram. I may move to being more active on Reddit. So you guys can help me out, but you can help yourselves out by sharing the information, understanding the information, helping to explain it to others, going out and downloading some of these books and reading them. And if you have any questions, post them in the comments. I'm happy to find the information or try to answer you in the best way that I can. And maybe together we can become the sleeping giant and end this tyrannical system in the way that it is. That's not to say I want to end the Constitution or totally dissolve the federal government. I just want it to do what it's supposed to do, and only what it's supposed to do. And then stay out of our lives, to be left alone, so that we can get on with our lives in a free, sovereign, and independent way. Okay, so like, share, subscribe, share, and I'll see y'all in the next video.